and also Michael Jaafar with us as well, national trial attorney. Thank you both for weighing in on this case. It's a difficult one when you see those images of Chloe Jones's face, what she endured those 4 days, that this man who had been convicted before for kidnapping a woman and doing things, assaulting her. Ron, this judge has a very important task in this case. Every judge does, but for a case like this one, where there's a prior history, there is much more pressure, is there not? Ron, I think you're on mute, so I'm going to give you a chance to unmute yourself and start again. If not, we will go to Michael and get your audio checked. All right, Michael, you weigh in, and Ron, we will work on your audio.
This judge has a ton of pressure on her, but I think this is an easy one. I think she's going to sentence this character to the max. To my understanding, there are 4 different charges he pled guilty to. The combination of them would be 25 years. That's my understanding of it. And so if that's, but the judge can say you have to serve these things consecutively. And so she could sentence him to the 25 years. I think she's going to do it. She's got a lot of pressure because there's a lot of community pressure. But at the end of the day, this one seems like an easy one to me, Julia. I mean, look at the tattoos on his face. Look at his prior convictions. Look at the torture he put her through. If this was a murder case, he'd be going away for 1,000,000 years. It's not a murder case, you know, so she's going to sentence him pretty aggressively. He's going to be in multiple decades in prison because of this. He is a menace. They use my favorite word in the elocution, which is you're a villain. He is a villain. There are villains in society. This is a villain. The judge is going to sentence him accordingly. There's no political reason for why this judge to give him any break. So that's what it comes down to. Right? When a defendant is in a courtroom and they have their family and his family's crying and he's awesome, he's great, he's found God, he's done all these things, that's when a judge will go beneath her maximum abilities. But there's nothing here. He's standing in this courtroom all alone. His courtroom demeanor says it all. He's even got tattoos on his eyelids. He's going to jail for the max. I think, in my opinion, in this case, the max is 25 years. The judge is going to give him that.
So he'll be 59. He's 34 now. The minimum 25 years, 59 years old. Michael, why do you think this wasn't an attempted murder charge? I know there's some nuances in Ohio, but your best bet on why there wasn't more potentially that the prosecution could bring against him?
That puzzled me. I looked it up, and he did not meet the elements of attempted murder in Ohio, especially given the fact that she went with him. There's many things about this case where the elements of attempted murder would have given him the chance to actually beat the case, whereas going after him with these combined charges basically would have given them, and did give them, a better sentence than even an attempted murder sentence would have given, right? This was a unique situation with unique facts. So I thought about this, Julia, on the break. Had this judge sentenced 4 different defendants on each one of these charges, but each defendant had only one of these charges, so one of them had strangulation, one of them had felonious assault, one of them had kidnapping, one of them had abduction. She sentenced these 4 defendants separately. I don't think the combined sentence would have been 25 to 31 years. I think it's because of the fact that this situation was a horror movie. Right? This is basically, if I watched a horror movie with this fact pattern, I would say, this is kind of a stretch. It's not believable, right? Dousing her with gasoline and telling her, if you do anything, I'm going to light you on fire. You're never going to see your son again. So I think the combination of everything is why it culminated in a bigger overall sentence. But in Ohio, I don't think they would have been able to meet the burden of attempted murder. That definitely would have went to trial. I think, I'm guessing at this point that it would have went to trial, but it might have even pled down from that. So I think the right thing happened in the way the state handled it.
He is going away for a long time, and no appeals because he pleaded guilty in this case. Ron Zambrano and Michael Jaafar, that's all the time we have for now, but thank you for being with us. Michael Jaafar is sticking around. Coming up, we are going to head to Georgia, where testimony has resumed in the Colt baby murder trial.
Well, one of the things that I wonder about the prosecution's theory of the case, in opening, we heard them say that the motive they believed was the defendant, wanted to be with her husband of 3 wives. And the problem I see with this, Michael, is that she did not only stab to death her 13-month-old. She also stabbed herself, and she had critical injuries and then recovered from those. How does that fit with this idea of she was killing the baby to be with him?
I think it fits pretty clearly to me, because she was trying to get attention. Stabbing herself would be, they'll argue it as a way of her bringing attention to herself. She was clearly not a well-adjusted person. What she did was completely grotesque. If this is not insanity, I don't know what is. I'm not saying that she should be found not guilty by reason of insanity, but this is definitely not a well-adjusted person. Maybe sending a text message is a way of getting attention, but stabbing your kid and stabbing yourself, that's something different. That's a whole different level. And as Jack said, the emotion was pouring out of the witness box by that by the detective. I have somebody that works for me, has his father-in-law as a murder detective, and he says they go through counseling every month because their jobs are so grotesque and so difficult, and so it doesn't shock me.
Yeah, and let's look at beautiful little Hannah. I think every baby's beautiful because I love kids, but I want to show her, the victim, one more time in this case. Coming up next, we're going to have more testimony in the cult baby murder trial for Chloe Driver. Plus, and while they're on the break, let me bring back in Michael Jaafar. Michael, it's really not a case of whodunit. We know she slit the baby's throat. It's really, will the insanity defense prevail? What does it entail?
My God, that's a great question. You know how much I love answering that question. So the burden is on the defense. The defense has to prove by a preponderance of the evidence that to all 12 jurors that she should be found not guilty by reason of insanity. I don't know if they're going to do it. I've long since said that maybe as a society of jurists, we should all agree to just change the name of that defense, keep it the same, but from not guilty by reason of insanity, let's change it to guilty, period, insanity proven. Maybe it would be a little bit more palatable for jurors. And one more thing, Judge Jesse, I always advise attorneys when they want to embark on this defense, my advice to them is waive the jury. Don't let the jury do this. Waive the jury, put it on the judge, let the judge be the trier of fact. The judge understands the law better than any of us, and even though this is a finding of fact, really we all know that this is really understanding the law and understanding it well. The genesis of the law, the way the law got to where it is today, it's such a deeply legal analysis that a trier of fact has to make to find that this woman that we're looking at was not guilty by reason of insanity, or as I say, guilty, period, insanity proven. It's such a difficult thing. It's unfair to put this on a jury. People who are, workers, employer, these are not people that were built to make this analysis. So do I think that it'll be found? Whether or not I believe it's found or not, I just don't see a jury. I haven't seen a jury in a long time reaching that conclusion. So we'll see what happens.
And often it's the battle of the experts, because they're going to hear experts on both sides say she was or was not insane at the time of the crime. Thank you, Michael Jaafar, for joining us.